In 2011, Leslie Mayfield was arrested for attempting to rob a drug cartel stash house. Only the stash house never existed. Mayfield was set up by an informant for the Bureau of Alcohol, Tobacco, Firearms and Explosives. Even though the stash house was a farce concocted by the ATF, and Mayfield technically didn't rob anything because there was nothing to rob, he was charged and convicted as though he did. According to a New Yorker article, undercover operations like stash house stings are subject to few constitutional or legislative restrictions. There are no clear legal limitations on the length of the operation, the degree of deception used, the degree of temptation offered, or the number of times it's offered. Also, because these stings involve drugs and guns, and federal sentencing rules are fairly severe when it comes to drugs and guns, defendants of stash house stings can be subject to particularly harsh penalties. Before Mayfield agreed to rob the fake cartel stash house, his coworker, the ATF informant, pestered him to deal drugs, offered him cash, and ultimately took advantage of Mayfield's situation as a person desperate to better his circumstances. The informant also told Mayfield to bring friends and guns. When Mayfield and his friend arrived at the supposed stash house, they were surrounded by federal agents and arrested. Both men were convicted and sentenced to over 20 years in federal prison. Mayfield appealed his conviction, and it was during this appeals process that his case was taken up by the Federal Criminal Justice Clinic at the University of Chicago Law School. Over the next 4 years, the clinic sought to prove that the ATF violated the 14th Amendment Equal Protection Clause by unconstitutionally discriminating on the basis of race when selecting its targets. Leslie Mayfield was Black, and as it turned out, 91% of all targets selected by the ATF between 2006 and 2013 were Black or Hispanic. From the Drug Enforcement and Policy Center at The Ohio State University, this is Drugs on the Docket. Each episode will tell the story of how U.S. court decisions impact drug law and policy and continue to shape the war on drugs. I'm your host, Hannah Miller. Today, we begin part 1 of a 2-part episode covering 7th Circuit stash house litigation and compassionate release. If you like what you hear in today's episode, visit go.osu.edu/drugs on the docket to follow the series. It's good to be back, Doug. I have been so excited for these guests since we began planning for season 2. I think that you have talked about their groundbreaking work in litigation surrounding these so-called stash house stings. So here we are. It's happening.
Yeah, and I'm excited too. So looking forward to it.
Without further ado, will you please do the honor of introducing our guests for today's episode?
Absolutely, Hannah. Thank you. It's my pleasure to first introduce Alison Siegler. Alison is a clinical professor of law at the University of Chicago Law School and the founding director of the Federal Criminal Justice Clinic, the nation's first legal clinic devoted to representing indigent clients charged with federal felonies and focusing on combating mass incarceration and racial inequity in the federal justice system. Before joining the University of Chicago Law School faculty, Alison served as an attorney with the Federal Defender Program in Chicago, was a Prettyman Fellow, I think I've got that right, at Georgetown Law Center's Criminal Justice Clinic, and a law clerk for U.S. District Judge Robert W. Gettleman. She graduated magna cum laude from Yale College, earned her JD from Yale Law School, and also holds a master's in law from Georgetown University. Well, Alison, thank you so much for being with us today.
Thanks, Doug. I'm really excited to be here.
I'm also excited to be able to introduce our other guest, Erica Zunkel. Erica is a clinical professor of law at the University of Chicago Law School as well, and she teaches in the law school's Criminal and Juvenile Justice Clinic. Though prior to joining that clinic, Erica supervised students in the law school's Federal Criminal Justice Clinic. Before joining the University of Chicago's law school faculty, she was a federal public defender in San Diego, California, and a law clerk for U.S. District Judge Martha Vasquez in Santa Fe, New Mexico. Erica received her BA from Cornell University and her JD from the University of California at Berkeley School of Law. Thanks so much for joining us, Erica, and being yet another member of our conversation today about a topic that has, as Hannah said, had me excited for quite a long time, the work the two of you have done in the stash house sting area.
Thank you so much for having us on. I'm also very excited to be here.
So while prepping for the episode, I found myself unlearning a lot of preconceived notions that I had about, number one, the role of law enforcement in the context of drug busts or drug-related busts, and two, the role of judges in the litigation process. My work is mostly legal adjacent, so I'm usually able to take like a 30,000 foot view to understand what's going on. But in this instance, I really had to get down and familiarize myself with the details. And the devil really was in the details, and therefore your victory was in the details. So before we jump into any particularly substantive, specific question, I, for the listener's sake, would like to stay at cruising altitude and briefly lay out the work that you did together in the Seventh Circuit over the course of many years. So let's back up. It's 2014. Your federal criminal justice clinic at the University of Chicago is invited to help litigate a stash house appeal. There are other cases like this case. So you convince the other defendants and their attorneys to coordinate with you. You decide you're going to file motions to dismiss these cases on the basis of racial discrimination. You get the data, you get the expert, you have an evidentiary hearing in front of all of the judges of all the cases in the Seventh Circuit. And as a result, you get plea deals, saving 43 defendants from cumulative, like hundreds of years of incarceration. Sounds like a cakewalk. Sounds super simple, guys. But obviously it wasn't. Let's descend then to like 10,000 feet. So what is a stash house sting? How do these law enforcement and prosecution tactics play out compared to a more traditional drug bust?
When we talk about these fake stash house stings, people literally think we're joking. Like they can't believe that this kind of thing actually happens and that there's an actual crime in it, and that it's actually legal for the government and law enforcement to pursue. So it's very different than an ordinary drug bust. In a stash house sting, you have federal law enforcement officers like creating a crime and choosing individual people to commit that crime, targeting individual people on that crime. So the way it all goes down is like this undercover federal agent, often from the ATF, the Bureau of Alcohol, Tobacco, Firearms and Explosives, approaches an unsuspecting person, often desperate person, and says, hey, like, I've got this get rich quick scheme for us. And the agent acts like he's a drug dealer. And he says, I work for a cartel and we can go to the cartel's stash house and there are huge quantities of drugs there for the taking, worth $500,000 or more. And they can be ours in a short day's work. And the agent then says to this target, this stash house can be heavily guarded. And so you're going to need to bring along friends. You're going to need to bring along guns. You're going to need to have your friends bring along their guns. And then the fact is, like, this whole thing is completely fictional. It's totally made up. There's no stash house. There's no drugs. There's no guards. There's none of this. It doesn't exist. It's a figment, right? But when the person, this targeted person and his friends and sometimes family members arrive at the designated place, they are charged with incredibly serious federal crimes for attempting to steal non-existent drugs from a fictional stash house. And the thing that is the most horrifying about all of these horrifying things is that 92% of the people who the feds target to commit this crime are people of color. So 635 people have been targeted across the country during the 2000s. And the way that prosecutors and police set this whole thing up, there's these really long mandatory minimum prison sentences attached to every single case. So people go to prison for between 15 and 25 years, and it's even possible to get life in prison, mandatory life for this entirely made up crime. And I just want to say it's not just a Chicago issue. Like during this same time period, almost 100 people were charged with this fake crime in Chicago, but at least 60 people were charged with it in LA. And in New York, for example, 179 people were charged with this. And in the New York cases, every single person who was charged was a person of color. So just to give you a sense, that's what we're talking about here.
That's wild. Can you talk us through the difference between racial discrimination and entrapment? And then in this context, why you ended up taking the approach of racial discrimination and why entrapment did not apply in this instance?
People have been trying to challenge these kinds of cases for a long time, and they were challenging them in various ways. And one of the ways was entrapment, trying to mount entrapment defenses. But it's almost impossible to establish entrapment at trial as long as the prosecution can show that somebody was predisposed to commit a crime. then it's not entrapment. And, they can use almost anything to show predisposition, including like drug addiction. And that's as an oversimplification of entrapment law, but that's, I think, sufficient to explain why we didn't feel that that was the right way to go about fighting these cases. Like almost every single person who's ever tried to fight these cases as entrapment has gone to prison for decades. And literally, like, one of the only people who was ever acquitted was represented by my colleague here, Erica Zunkel, acquitted at trial on an entrapment defense in one of these cases. But that is the total rarity. And only because she's such an extraordinary trial lawyer did that ever happen.
Really quick, can you briefly explain how these cases were brought to your attention?
Some federal public defenders and CJA lawyers in Chicago, they were the ones who came up with this brilliant idea of let's attack these cases as racially discriminatory instead of using entrapment. And so one of those lawyers was Candace Jackson-Acumi. She's now a judge on the Seventh Circuit Court of Appeals. Another was Chicago attorney Stephen Saltzman. I just want to shout out to them because they really did the early work here, and they consistently did work here. And they did the heavy lifting at the beginning of this, because what they did is they convinced several federal judges in Chicago to order prosecutors to turn over these internal ATF documents about the stash house tactic. And another thing the judge ordered was made the prosecutors turn over the name and race of every single one of those like 94 people who were charged in Chicago in these cases. So the way things went down, like after the federal public defenders and that original group was able to obtain like the ATF's playbooks and some other key discovery materials, the federal prosecutors, as I mentioned, they appealed, right? The government sought review of that discovery decision. And the attorneys on that case then reached out to me and said, can you help us defend this decision to the Seventh Circuit so that the defense can keep all the discovery, the playbooks, everything we've gotten so we can actually keep litigating. And we basically we lost the battle, but we won the war, because what the Seventh Circuit said is they were like, this one judge's discovery order is too broad.
What exactly were you allowed to get if those orders were too broad?
So there were a number of discovery orders that had been issued from different judges, but one of them went up on appeal. And in that case, the judge had actually said, I am granting discovery not only about law enforcement and what the ATF did here, but also about what the prosecutors did. And there is a Supreme Court case from the 90s called U.S. versus Armstrong, which was very clear that it is incredibly difficult to get discovery about any allegation of racial discrimination by prosecutors. And so by that judge kind of lumping prosecutors and police documents together, the Seventh Circuit said that's too broad. But in the course of explaining why it was too broad, the Seventh Circuit really separated out the concept of discovery from the police files and discovery from the prosecutor's files. And the Seventh Circuit said, if you're asking for discovery about actions by the police, it's really not as onerous a standard. So what that meant was in this negotiation, we were able to say to the prosecutors, look, in these other cases, all the judge ordered was discovery about the ATF's actions and the discovery of the ATF's playbooks, not discovery about prosecutors' behavior. So we should be able to keep the discovery that relates to policing and that we believe is necessary to help us move forward with this litigation and with these motions to dismiss. Then the interesting thing is, Hannah, that Armstrong case was not just an impediment and a hurdle to getting discovery. It was also an impediment to how do you prove racial discrimination by the police such that you can get a case dismissed, the merits standard, basically. And what we decided was that in order to meet this Armstrong standard, we needed certain data, both from the federal government and the ATF, but especially we needed data that was not in the hands of the feds.
Can you speak a little bit more about the decisions that you made as it pertained to getting access to the data and presenting the evidence? Because federal agencies aren't just handing out their playbooks. I'm sensing there was a considerable amount of strategy, just to get the data.
Yes, Hannah, so much strategy went into all of this. The thing that our clinic, I think, really contributed here is how do we go about trying to actually dismiss these cases on racial discrimination grounds, not just getting the discovery, but the substantive motion to dismiss. And I just want to also say that another attorney in our clinic, Professor Judith Miller, played an absolutely pivotal role in developing that strategy and in litigating these cases for 4 long years. And the law students in our clinic, I have to say, worked side by side with us, drafting motions, making incredible contributions every step of the way. It took years of litigation just to get the data that we needed for our expert to be able to conduct a statistical analysis that we felt was necessary in order to convince judges to dismiss the cases.
Okay, so then back to Armstrong. How did you meet the merit standard now that you had the data? Or what was your plan?
What we decided we had to do to meet Armstrong was compare the racial composition of two groups of people, okay? First, the group of people targeted by the ATF in the Chicago stash house cases, which I said was about 94 individuals. You had to look at their racial composition. And then you compare that with the entire universe of people available to be targeted for such an operation. And how do we find out who's in that second universe? You have to take the ATF at their word, basically, and see what are their criteria for conducting these operations. And so what the ATF's playbook said is, we are going after people with prior convictions for drugs, guns, and violence. And so that's when we had to subpoena the Illinois State Police to find out who is like the entire universe of people out there in the world who fit the ATF's criteria. And so I dropped the subpoena on them like in February of 2015. And they immediately moved to quash the subpoena.
Like Valentine's Day, here you go, guys.
Right.
With love from Alison.
It was a very long subpoena, too. And we ended up in 9 months of really intense litigation with them, had to file like hundreds of pages of motions. Our students were working round the clock on this stuff just to get that prior conviction data. And at first, actually, again, this was another one of these like horrible, devastating losses. The judge denied this request. He granted their motion to quash the subpoena. And so I was actually at Disney World with my kids, and Professor Miller and I, just worked like 80 hours a week during this spring break, trying to file a motion to reconsider. We had to get declarations from expert witnesses in order to establish, look, we cannot prove our case unless we get this conviction data. And miraculously and amazingly, the judge reversed his ruling and enabled us to move forward. And again, all that is all we needed just to get the data for our expert to begin to analyze so that we could begin to try to meet the legal standard. But yeah, ultimately what happened was we got the data for the expert, Professor Jeff Fagan at Columbia Law School. He had been the expert on the very successful New York stop and frisk litigation. And one of the things that we did here that was so unusual and rare and unique was we decided to ask this expert to work on behalf of all of the 43 clients who had been charged with these crimes and were still pending trial in Chicago. We were basically at that point kind of leading and coordinating the litigation across a lot of different lawyers in 12 different cases in front of 9 different federal judges.
So I'm going to jump in here and I'm going to ask, so once you get the data or you have this information, I'm sure you had a sense of what it was going to show, but then getting it to the expert, doing the analysis, and then also being able to convey that. I'll speak not entirely on behalf of the entire lawyer class, but we went to law school to avoid doing math. And so to even understand how to make sense of this in a sophisticated way, was that fun, hard, easy, something students helped with? What was once you get the data, getting to the point where you get the kind of expert report that can actually get you to have a hope to win the case?
Yeah, I'm so not a math person. Like, it is not my forte. Eric and I and Judith, we all had to get sort of educated in statistics. The good news is I feel like we became, just as you have to do in any kind of litigation, in any kind of case, you become an expert on the things that you have to become an expert on in order to do your best and most zealous job for your clients. And we did that. Like, by the time we were, in the evidentiary hearing and I was doing the direct examination of our expert witness, I absolutely understood everything there was to understand about every aspect of his report.
There's so many things that are unique and quite groundbreaking about the work that you all did in this setting, but that sort of combination of being able to build almost a class action structure and get relief for many people, which is often so hard to do in a criminal justice setting, when in lots of arenas, and I'm sure this came up a little bit in your groups of cases, the prosecution will say, well, this one's different for these few facts, and that one's different for those few facts. And so just building that entire network that way. And yet at the same time, and this is where the racial discrimination argument strikes me as so powerful, it is only because of the kind of class nature of this that judges can both see and understand that this isn't a one-off situation, that they may be, I don't know if you would confirm the sense, actually more open to the idea that this is a systemic problem that needs a systemic remedy rather than just the one entrapment case or, dicker over each detail for each individual defendant, whether they were more predisposed or not. And so, it's both the challenge of litigating this and yet at the same time, the power of it because of the nature of the claims you guys were able to build. It's very impressive. I'll just put it that way. And I can't imagine the amount of work involved at every stage of this because it gets to the heart of not just what's hard to do in an individual case, but to have to coordinate. And the stakes are so high, I'm sure it got the government's backup as well in so many ways.
Thanks, Doug. It was very intense and really the hardest thing I've ever done. At the same time, the government, it would have been to their benefit if they could have convinced the judges to consider these cases separately. And they kept saying, no, Judge, this is just one case. This is just one case in front of you. And we kept saying, no, Judge, there's all these cases in front of all these judges. And one of the great victories here, and again, one of the really unique things I think we did in our strategy was we were able to go to especially a couple of the judges and say, hey, listen, we think the very best and most efficient, people like efficiency, way of approaching this whole litigation is we're going to file motions to dismiss on behalf of all 43 of these individuals in front of these nine federal judges. Let's have a single unitary evidentiary hearing where our expert will testify, the government's expert will testify in front of all 9 judges. And it was quite extraordinary, actually. I mean, this is just unprecedented. This does not happen. District court judges sit individually on their cases. They do not sit as a unit like a court of appeals or like the Supreme Court. But in this situation, we were able to have this amazing, massive hearing in the ceremonial courtroom of the federal courthouse in Chicago, which has an actual judicial bench that looks a lot like the Supreme Court of the United States, with all of the 9 judges arrayed just exactly like the Supreme Court, and us at podiums and our witnesses down in the well of the court. It was like unbelievable. And then our clients were actually all in the jury boxes. It was so sad and also striking to look out at that courtroom on the first day of the hearing and see our clients in the jury boxes. And our clients were almost universally people of color. And so it was like sort of exhibit A of the racial discrimination that we were alleging was sitting right there in the courtroom. And I think it was very striking for the judges too. I think they really did say, wow, it was just so clear, like who is being targeted by this operation.
So in a regular evidentiary hearing where you don't have all of the judges together, it would have played out the way you had envisioned it in terms of it being you, the expert, back, forth. Maybe the judge would jump in with a question, but adding all of those other judges in, it must have felt like whack-a-mole in terms of, fielding everyone's inquiries. And so I can imagine that was it fun?
It was fun. It was one of the hardest things I've ever had to do in a courtroom ever by far. I mean, it's harder than, it's funny. It was a hearing, just quote, a hearing, not a trial, but it was harder than any trial I've ever had because of the intense, sort of level of statistical knowledge and trying to convey the statistics at that point, both the expert and I trying to convey them in a way that would be meaningful to the judges. He was really able to show in his report that the ATF had targeted Black individuals in a racially disparate way. And specifically what he found was that in these stash house operations, the targeted group of people was 80% Black individuals, while the racial composition of that big universe of people who met the ATF's criteria was just 55% Black. And what Professor Fagan concluded was that there was a 0% likelihood of the ATF netting a group of people that was 80% Black from that universe by chance. And then in addition to that, he conducted these 3 separate regression analyses that just ruled out all of the potential race neutral explanations for the decisions the ATF was making. And ultimately that led him to this conclusion that the ATF was discriminating on the basis of race, a statistical conclusion.
And did the government have a corresponding expert who said, it's all just fine? Or did they just try to sort of pick holes in what your expert was presenting? And then I certainly want to make sure we get to, and then what happens when the judges process all this evidence and react and respond?
The government brought in their own expert, and his job very much was to, as you say, poke holes in our expert's analysis. And unfortunately, it's easier to poke holes in something than it is to do the original analysis, right? There's a lot of ways statistics can be poked and prodded at and pulled apart. And it kind of felt like their expert was like, look over here, judges, look over here, ignore the fact that it looks like racial discrimination. And like, instead, I'm going to take you down this rabbit hole of something you don't really understand, but it sounds kind of good. And that was frustrating, and actually Professor Miller did an amazing cross-examination of the government's expert on this.
I've already decided your description of the scene of this hearing absolutely should be close to the climax of the film they need to make about all of the work that you've been doing. You guys know the story well, but it connects to some of the previous season's work that we've done on the crack powder disparity. And I remember being a witness at a hearing where they brought in a group of defendants right after the Fair Sentencing Act passed, and they were trying to figure out who it should apply to. And it's just, one African-American man after another. And you just realize, all right, there's data, these are statistics, but they're real people, and real people who are the consequence of a racially skewed system and one that you expose this way. So now we got to get to the true climax of the story. So what happens? Tell us in all the details in the resolution that you got for your 43 clients.
Our 43 clients in Chicago, in these cases, originally, as I said, we're looking at enormous amounts of mandatory prison time, right? 15 years in prison for some, 25 years in prison for others, mandatory time. Other people were looking at that mandatory time plus 10 more years under the guidelines. I mean, it was the numbers, the amount of prison time and incarceration was just extraordinary and horrific. After this big evidentiary hearing, I think the prosecutors definitely could tell, some judges seemed they were more on the prosecutor's side, but certainly there were judges who seemed like they were more on our side. The prosecutors ultimately offered to dismiss all of the mandatory minimum charges against every single one of the 43 clients, which was really, again, that's also unprecedented. It's extraordinarily rare for a federal prosecutor to dismiss a charge, even partway into a case, certainly years into a case. The prosecutors, though, were still seeking these high sentences under the federal sentencing guidelines, somewhere between 15 and 17 years, depending on the client. But as a result of the dismissal of the mandatory minimums, we were able to do zealous sentencing advocacy. Our clinic had done a lot of the motion to dismiss litigation, but at the sentencing stage, all the other lawyers who had been involved in the case stepped back in and began litigating sentencings on behalf of their clients. And a lot of clients, most clients in the litigation ultimately ended up with what's called a time-served sentence, meaning they were released back to their families immediately on the day of sentencing. And so some of those folks had been in jail for, up to 3 years already. Some folks had actually been in jail at the beginning of the case and had gotten released on bond. And our clinic got one of our clients released on bond. He walked into the courtroom on his own steam and he walked out. And we have, beautiful pictures of our students standing with him and his family outside the federal courthouse, celebrating his ultimate release and his ability to stay home with his kids and with his family and continue his job and do all the things that he was doing. It was also just so clear at that point that they shouldn't have been in this situation. They shouldn't have been put in this situation. They shouldn't have been looking at decades upon decades of mandatory time.
Is it right to speculate that the Department of Justice did this unprecedented dismissal of all these mandatory minimums so that they wouldn't have to face a ruling actually on the racial discrimination claim? And so just to be clear, is there a formal legal finding or something kind of on the record from the judges about how this all played out? And I'm asking that in part because is there something to cite for the next case and the next case? And I'm sure there have been a range of other ripples beyond just the impact for your clients, but would love to hear a little bit more about that. And then we'll turn to some broader questions with Erica as well.
Even though we were in the midst of these negotiations and we told the judge, we're like, look, it looks like all of our clients are taking these plea agreements. Please just don't issue anything at this point. One judge decided to issue an opinion finding against us, saying, look, there's a lot of evidence here, but I don't think it rises to the level it needs to rise to warrant dismissal. And it was really interesting because the first 6 pages of the judge's opinion decried the horrors of these cases, talked about the problems of racial discrimination in the country and in the criminal justice system. And then the ultimate result was not what we wanted. But it was interesting because Erica and Judith and I felt like if anyone, even a single one of our clients, wanted to continue litigating, we were going to take it to the mat. We were going to keep going and going with this litigation and trying to get their case dismissed. There was a piece of us, I think, that was like, we knew there were some judges who were going to go the exact other way. And we were so hoping to see one of those opinions, but we didn't ultimately, because our clients took these deals and they got absolutely the best result for themselves. And that was all that mattered ultimately, was not, making that law, but getting our clients released. We actually did change the law, though, in a really interesting way at the appellate level. So the appellate victory that we'd had made it a lot easier for the defense throughout the entire Seventh Circuit in future cases to get discovery about racial discrimination by the police. And then these two other federal courts of appeals actually sort of made it even easier. They cleared out additional hurdles to getting discovery about racial discrimination by the police. So when we started this whole litigation, it was like you had to present evidence of discrimination in order to get evidence of discrimination. It was like a total catch-22. But as a result of our litigation in the Third Circuit, in the Ninth Circuit, and in the Seventh Circuit, these really fantastic rulings came down, which just absolutely changed the state of play. And it's interesting because there actually is, for the legal nerds out there actually is a circuit split on this right now, with the Third and the Seventh and the Ninth on one side and the Fourth and the 10th circuits on the other side. It hasn't gone up yet, but it's there. One other thing I just want to say that I think is like one of the most extraordinary victories of all of this is our litigation shut down this whole stash house operation in Chicago. Like, federal prosecutors stopped bringing these cases. I've heard that the ATF wanted to continue bringing them, but the federal prosecutors were basically like, yikes, get this stuff away from us. This is making us look bad. I mean, that's my sense. And it was making them look bad. A lot of judges were really horrified by these cases and by what they heard in that hearing, what they saw in that hearing, And then I've also heard from a very reputable source that at this point in time, the operation has basically been shut down nationwide. And I have personally not heard of a new stash house case in a number of years. And no one has, actually. We've been keeping our ear to the ground, and we haven't heard of anything.
The 43 defendants of the Stash House litigation had not yet gone to trial, taken plea deals, or been sentenced. So, what happened to the other defendants who'd already been moved through the system and were not part of this litigation? Find out in the next episode when we continue our conversation and hear from Erica Zunkel.
We knew that there were about 40 other people whose cases were already closed. Their convictions were final and they could not join our litigation. They have exhausted most of their post-conviction remedies at this point. They were without hope. And there just wasn't anything at that point while we were litigating that we could do. But after it was over, we started to think about, was there anything that we could do? And we didn't know quite what it would be. But I think that is the wonderful part about practicing in a law school clinic. We were really pushing the boundaries, being creative advocates. So in the fall of 2019, my students and I started a project to try to get these 40 plus guys out of prison, if we could, or at least start by trying to get a few out of prison.
Drugs on the Docket is a production of the Moritz College of Law Drug Enforcement and Policy Center. This episode is produced by me, Hannah Miller, and Holly Griffin. Doug Berman is our editorial advisor. The music is composed by Joe DeWitt.